that actually relates to one question we have from the audience here. I thought it might be fun to get into some audience questions here. One person's asking, do you ever have to argue both sides on a law school exam, or is it usually just one side? Oh, you want to take this?
That's actually a great question. And my answer is yes. Let me say what I mean. There is a meta skill that the professor is looking for, that the professor doesn't tell you that he's looking for. And it's something that I would call, I'm still trying to find a better kind of buzzword for this, but it's legal judgment. When I say, not every issue on an exam is 50-50, close questions. There's a range. There are some issues that actually are slam dunks, and you have to pick those up. There are issues where someone might not win, but the argument is what we would call colorable. That is a super important distinction. So let me back up. The specific answer to your question is kind of both. Sometimes you'll have to argue both sides because the facts point to a very close question. Sometimes you kind of follow the facts where they go. Sometimes the facts will point to a really easy question where the other side doesn't have a great argument, and you don't waste a lot of time with that. You say, this person would probably win this easily because blank. And you can kind of go through the range. The most important thing, the way that you know you've passed through the veil of sanity and into the insane world of becoming a lawyer is what I would call colorability. Here's what I mean by that. Remember that most cases are not developed by schizophrenic law students who are having to develop arguments for one side and develop arguments for the other side and then be a judge. I think that's why this kind of, the basic legal analysis is a super complex thing that you're being asked to do, and it makes me angry that the professor doesn't really explicitly acknowledge how hard, how many different tools you need to kind of do that well. But one of the most important things is if you can put yourself completely in the shoes of one of the sides. If you're an actual lawyer to someone, that client wants you to argue their side. Now, that's not the entirety of the legal analysis, but it's a part of it. And what you do is you don't just develop slam dunk arguments for your client. Sometimes your client's in a bad situation and doesn't have great arguments. All you can do is develop the best arguments that you can on behalf of your client. Sometimes that means you come up with something colorable. What colorable means, please keep this in mind, what colorable means is this is possibly not a winning argument, but I would not lose my license making the argument. There are actually rules that prevent lawyers from making ridiculous arguments or patently untruthful arguments, or those that are clearly contrary to the existing law. You can actually be sanctioned for that. So if you can develop an argument that is better than that, the reason you need to hear that is that's where the A's are. Everyone else will get the obvious points. But what the professor is looking for is sophistication in executing those basic things. But the thing that puts you over the top is being able to point out colorable arguments, those things that are not winners, but if you're before the right judge, this is the kind of thing where you might assess, like, this argument only has, and this is not what you would say on an exam, but kind of the mental models, like, if a winning argument's like you would win, 60, 70% chance that you would win, a colorable one is like 10, 20, 30%. Why are those worth raising? Sometimes your client's in a jam. I've had this. I've worked as a lawyer. I no longer work at a firm, but I worked at a big firm where our clients were all big companies. I worked at a small one. When you have individual clients, sometimes they do things that are not great. I had one client who simply failed to pay a bank back. And I'm like, this does not look like a great case. And he said, what can you do for me? So when you're put in that position, you kind of research different potential defenses or claims. And I came up with something that bought him time. I mean, it should have been the kind of situation where the other side just showed, and that's what they did. They were arrogant. They're like, this guy just owes us money. But the situation was a touch more complicated than that, and I kind of found a defense that helped buy him time. The judge didn't simply order him to hand the money over, and that gave him some time to kind of negotiate a settlement. When I developed it, I didn't think this is a winning argument. I thought this is the best I can do, and I won't be kicked out of the law as a practicing lawyer in developing it. So again, that's a long answer, but a lot of this stuff is a little bit complicated.
Thanks for that, Larry. It's reminding me of in debate when they have you make an argument for the opposite side of which you were assigned, or they might assign you to argue a side that you're not really in favor of, but your job is not to argue necessarily what you believe, but in the interest of your client or in the interest of simply the side that you've been assigned to deal with. So thanks for that. This person responded, that was great. Thank you. So
can I add just one?
Yeah, go ahead, please.
Sorry, I was going to add just one more thing. I think that the idea, the question that I guess Ijenma asked is super interesting because you only see one side of it. A lawyer has a couple of hats, at least a kind of trial lawyer does. In court, all you ever see, like when you watch a TV drama, most of what you see is the lawyer in his role as advocate. So the lawyer in court is only arguing one side, is always pushing back on the other side, is always trying to pick holes in the other side's arguments. But before that lawyer gets to the courtroom, she's a counselor to her client. And so that requires not having a kind of one-sided view of things. If you did that, so you have a role and you have to play that role correctly. When you're in court, you're all for your client. You actually have a professional responsibility to be a zealous advocate on behalf of your client, unless you work for the government. That's a different story. But when you're playing the counselor, you're counseling and you're offering flat, objective advice to your client, where you have to kind of see both sides, where you have to have anticipated what the lawyer on the other side, just like the bit in debate where you have to kind of present on the other side of the topic that you just presented on, you have to be able to think, put yourself in the shoes of the other side to ask your client awkward questions. So I think better legal procedurals show that process where you see, the lawyer talking to the client acting skeptical, and then in court, she's all fire and just, a tiger. But as a counselor, you do both at different times. On an exam, you have to kind of do both. You develop the arguments on both sides, and then you step out of that role, and then you act as a judge, interpreting case law and kind of predicting where things would likely land. So sorry, that's a little bit I wanted to add.
No, that's great. Thank you, Larry. And it's really interesting to hear not only about what to do to prep for law school, but also more about what lawyers actually do aside from necessarily all the drama of TV and movies. And back to the law school prep side of things, we've got two questions that are somewhat related about law school prep. One of them is specifically, when we talk about the summer before law school, are we talking about the summer immediately before one starts law school in terms of starting to prepare? Or are we talking about, let's say you just finished college, June after senior year, but you might not go to law school immediately. Is it too early to start prepping? And then when you do start prepping, how do you recommend starting to prep specifically to get used to law school exam style questions?
Those are also great questions. And I would also say, oh my stars and garters, I can't believe that there are people who want to prep right after college before you get to law school. So I think the earliest you should be prepping is when you know you're headed to law school. There's a book that I've recommended on my website called Planet Law School 2, and he has a totally insane prep plan that involves getting ready a year in advance. If that's you, and you're not, so let me say something that's partly in Steve's interest as well. Do not multitask. If you're not in law school yet, just do LSAT. Don't start thinking ahead to law school. Once the LSAT's out of the way, once you've gotten into a law school and you've gotten into the best law school you can, you've got the best kind of combination of best law school and best financial package you can, then think about law schools. For some people, that's the spring, and I've definitely had students start to prepare as early as the spring. For practical purposes, a lot of people are going to law school right out of college. You need to finish college. You need to still get good grades and kind of live your life and enjoy the end of college. So practically speaking, that leaves the summer. And then, so the other part of that question is how you recommend prepping to get used to law school exam style problems. So let me, I can be neutral about, I do have a particular solution, but in the abstract, there are places that you can get law school exams in advance. Now, the problem is you don't know any law. What you can do is study commercial outlines. Now, what do I mean by commercial outlines? There are two big brand names, Emanuel's and Gilbert's, and these are kind of classic law school supplementary materials. Most professors don't like them. I have an entire post on my website and Above the Law. That one eventually got me kicked off Above the Law, but we can talk about that some other time. As to why professors don't like those materials. But what you do is you can, what I've called pre-study the law. There is usually at the beginning of a Gilbert's or Emanuel's description of all of the basic claims and defenses you'll learn in a given subject, like contracts. Now, in Emanuel's or Gilbert's is usually 300 to 400 pages long. It can be very detailed. There is a short outline at the very beginning that covers the basics, and it's almost what you would use to study for the bar exam. A 30 to 50 page outline. It's the condensed capsule outline. And it will just, for instance, offer the core elements of a claim, like battery is an intentional offensive touching without consent, like 1, 2, 3, 4. And you begin to kind of learn what those elements are. That will enable you to kind of spot issues as you see just the bare fact patterns given to you. So you see somebody get punched in the face or somebody spits water on someone, you're thinking, oh, how can you need to have, so let me back up. You need to have what's called black letter law, at least some of it under your belt in order to begin to analyze exams. If you don't know any law, you can't do that. Notice what you don't have to do. You don't have to have read every case to be able to do that. There's a reason why I think you should still read the cases as you go on, but people will read them obsessively. Let's back off of that. In order to, in this early kind of preparing season, whether it's the summer, or you can even what I call side study during the year to kind of cut down on the time you spend at the casebook, you begin to learn the black letter law. The black letter law is the material that you use to apply to kind of create legal claims and defenses on exams. So there are two pieces, right? You actually get the subject matter outlines for contracts or torts or property or whatever. You pre-study that. You can just study the capsule outlines in the Emanuel's or Gilbert's. And with that knowledge, you can get practice exams, which are available. You know, you can type in like practice law school exams or law school exam banks. And there are some law schools. Berkeley used to have a good one, but they just closed it to the public this year. A couple other schools, I think University of Kentucky, a couple of others have open banks that you can begin to start to work with. My own website, my course, tries to solve this problem by offering you snippets of law so that you don't even need to know any law in advance. And then you can kind of work on a hypo, and you can start small and kind of work your way up to more difficult problems. But that's basically it. You find an abbreviated way to study the law, to actually know the black letter law that will be applied on exams, and then you take some exams.
Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I'll wish you all the best and take care.